Hello. Tia, am I audible to you?
Yes, ma'am.
Okay, let me know when we have to
Am
start.
I audible, ma'am?
हाँ जी दिया जी.
Ma'am, if you can please share the screen because it is in internet connection lagging from my side.
I'll try.
Over 12 years of academic experience, a doctoral degree from Guru Nanak Dev University, Amritsar. Her research expertise lies in intellectual
Yes, ma'am.
property rights
Am I
with a
audible?
special focus on corporate law. We are confident that her insights today will enrich our understanding of evolving landscape of copyright law in India.
Good morning. Am I audible to you all?
Yes, ma'am.
Okay, I think
May we start, ma'am?
the slides are not. Yes, the slides are not available right now, but I'll start the session if that's fine. Yeah, it's just
Okay, ma'am.
it's still processing.
No issues, ma'am. We can start.
Yeah. Okay.
Good morning, everyone, and a warm welcome to this exciting online workshop organized by the Center for Development of Intellectual Property and Research, a premier institution under Indian Center for Child and Development Human Rights. CDIPR holds the distinguished title of being India's first non-governmental research organization solely dedicated to the promotion and protection of intellectual property rights. Operating as a part of Nowina Development of Intellectual Property and Research Foundation, CDIPR is a registered NGO that is at the forefront of fostering a robust environment for innovation and creativity in India. Today's workshop is a part of our ongoing commitment to providing insightful discussions and knowledge sharing on the critical aspects of intellectual property law. We are honored to have with us today an expert in the. Ma'am, you can start.
Okay. Thank you, Dia, for the introduction, and thank you for the opportunity also. So today I'm going to talk about copyright laws in India. Dia, is the slide available visible to you?
Not yet, ma'am.
But it's showing like that. Slide one, slide two. Like I can move the slides.
You can start,
I'll
ma'am.
try it again.
It will resolve in some time.
Just a second. Chalo, ठीक है. We'll start the session then because we are already late by 15 minutes. Okay, good morning everyone. So today we are going to talk about the complexities of copyright law in India. The session title is All Rights Reserved, but I'll be very clear that all rights are not reserved under Copyright Act. So let's start with the meaning and definition of copyright. So when we talk about copyright, generally, if I say what's the meaning of copyright, you can say that the person or anyone has the right to copy. So when I was teaching copyright, Dia was in the class. So I gave an example of a movie, Ghoomer, if anyone has saw. So in that movie, Abhishek Bachchan said copyright का मतलब सबको लगता है copy कर सकते हैं. But actually, it's not the right to copy. It's the right to copy only to the honor of that work that has been created. So I hope everyone is law student here, or we have students from different streams or people from different streams. So I'll go accordingly. Yeah.
Ma'am, they are from law.
Okay. So you all are aware about what is meaning of intellectual property. Intellectual property is something that is created by your mind, that comes from your intellect, your intelligence. So whenever something is created by your mind, that is intellectual property, and we have different kinds of intellectual property. That is very basic. I think all of you might be aware of that. So we have patents, we have trademarks, we have geographical indication, we have copyright, we have design, we have semiconductor. That is considered to be the most happening thing right now. So since we are going to talk about copyright only, I am not going to talk about other intellectual property rights. So copyright is a thing or a bundle of rights. It is not that you have the right to copy anything. So earlier what used to happen is कि जब हमें research करना होता था ना, so we used to go to the libraries. Like I'm an old school person, so we used to go to libraries. We used to write down a lot. So we used to work hard. But in today's time, when you have easy access to the internet, it's really easy to copy anything. Like in just a click you can copy the whole book and the thesis, you name it, and you have it on the internet. So it's easy to copyright. Ab copy karna is very easy. Earlier it was not that, but still in 1957 we needed that law so that nobody can copy whatever is created by my mind. Whatever is my intellectual property shall not be copied by anyone else. So I was given this right under Copyright Act where I can copy. It's not that copyright means that you can copy. The right, copyright, that gives me the right to copy my work. But now, even in these days, even self-plagiarism is not allowed. So I cannot copy my own work. So copyright talks about right in your work that has been created by your mind, and there is a class of work that has this copyright. A classes of work actually under which we get rights, different rights, not only the right to copy but a bundle of rights. So copyright, when we talk about intellectual property rights, copyright is one area where the person who is the owner of the rights get bundle of rights. Okay. So दिया slide दिख रही है? No.
Not at my side, ma'am.
Okay. So please try if you can share the screen, or if you can present, since I am not able to. Right? So
Okay,
as
ma'am,
far
I'll
as
try.
my screen shows, the slides are visible. Okay, so when we talk about copyright, so copyright is governed by Copyright Act of 1957, which came into effect on 21st January 1958, and it has been amended 6 times till date. The major amendment came in 2012, which we'll discuss at the later stage. So the meaning of copyright, as I said, it's the exclusive right to copy. And when we talk about meaning of copyright, so copyright is a bundle of rights given by the law to the creator of a certain classes of works. Those works are defined or given under Copyright Act 1957. So now, what was the purpose of copyright? So earlier, whenever we talk about intellectual property, any kind of intellectual property, so like I did my doctorate in patents and traditional knowledge. So we used to follow the principle of Vasudhaiva Kutumbakam, that we are a family. So if I have done one work, you can copy it easily. But then when people started taking that as granted, or like I was not getting the benefit, but other people enjoyed all the rights and benefits. So we thought that there shall be some restrictions to that. So Copyright Act 1911 and 1914 was passed, and then ultimately the main law that we follow now is 1957 Act, that was passed. So the purpose of this law was to motivate that the person, the author, the owner, the creator must have must be motivated to do more creativity. the activities that involve the creativity, that involves the mind, intellect of a person shall be more than, and the person who is doing that shall be motivated that he shall do more of that, not that I am doing that and someone else is getting the benefits. So the purpose was to motivate the creative activities. So now when we talk, so this is the meaning of copyright, that I'll get copyright, I'll get the rights, bundle of rights in a certain class of work. Now, what is that class of work? So, generally, the short term that is taken for it is LDMA. LDMA are the works that will get you the copyrights. LDMA is literary, dramatic, musical, and artistic work. Though we also have cinematographic film, sound recording section. This amendment of 2012 also added performers and broadcasters act, जो works होते हैं, they also get the rights under copyright. So if we talk about literary works, so literary works are defined under section 2 clause O of Copyright Act 1957. So whatever, if we take a simple word, that in simple words that means whatever is in black and white is literary work. So if a person writes a poem, any book, any article, research article, all those will be covered under the definition of literary works and will be protected by the Copyright Act. Dramatic works, so whenever it is not the cinematographic, different from cinematographic films is dramatic work. If you can just give me a minute. Okay, sorry about that. So, literary, dramatic, musical, and artistic work. So, literary, as I said, something that is in black and white is literary work. So, any poem written by you, any article written by you, any short story, any long story, any book, everything that will be covered under literary work. Dramatic work, where someone performs something, that is separate from a cinematographic film. It's not moving like it's not a series of pictures. Musical work, wherever a sound is produced, musical works. Artistic work, whenever it is some art is involved. I'm going to be very brief about these things. So any art is architecture, any art that is that has some intellect from a person will be covered under intellectual property rights. Copyright, sorry, I'm really sorry. Copyright. So there are few principles that are to be followed while applying for a copyright. One thing is please be informed that copyright does not need mandatory registration. The moment you write down a poem, the moment you write down an article, the moment you write down a book, and it is published, it gets copyright. It is not mandatory to. Of course, if you apply for registration and you get it registered in your name, that helps you to prove that you are the author or the owner of the copyright, but it is not mandatory that you shall apply for the copyright. Another thing, copyright all the works, whether it's a literary work, whether it's dramatic, whether it's artistic work, whether it's musical work, it shall be original. Now that is a big, big condition that is there in copyright. So what is original? I'll give you one example. If you people watch movies, so if any of if any of you have seen Ram or Sham, Sita or Gita, Ram Lakhan, not Ram Lakhan, that movie of Anil Kapoor, Kishan Kanhaiya. All these movies have same idea. So copyright, like other intellectual property rights, it is copyright is a incorporeal right. It is something which cannot be seen, which cannot be touched. But this right, this bundle of rights will be available only to the work that is there in the form of physical form, when it is a corporeal presentation. So you will not get any right in any idea. Idea does not get you copyright. I have this idea in mind, I cannot get it copyright. I have to present it in some way, whether it's through the performance where someone can see it, or whether it's in literary work, like say, like I'm giving you this example of Ram or Sham or Sita or Gita. So what happened is I had this idea that there will be two twins who will be separated, and then one will be very nice and very subtle, and another person will be very active and sharp, and there will be a villain who will be after their property, etc., etc. So all these movies I have named, whether it's Ramo Sham, Sita Gita, Krishna Kanaya, and Jurva also, they have this same idea of two twins, one being very subtle and very, calm, down to earth, and another very sharp, very active. And it's all about property. They get separated in that they are मिल जाते हैं कि ठीक है हम गुम हो गए थे एक भाई कहीं चला गया एक भाई कहीं चला गया and that is the basic idea of all these movies, but no copyright was infringed because the presentation of all these ideas were different. The idea is not original. The idea of movie Kishan Kanaya is not original. It is taken from movie Sita or Gita or Ram or Sham, whatever movie which that came first. Idea was taken. It was not original, but the presentation of that idea was original. That's why they get different copyright in all these movies. So the law says that the presentation, the way you present your idea, shall be different from the other. It shall be original. Ram or Sham has Dilip Kumar and different movies, different setup, different locations, different looks of the villain as well as hero, heroine, etc., etc., etc. Same when we talk about Sita Gita or Chalbaz or Kishan Kanaya, all the presentations were different. So when copyright talks about originality, it says you must have put in some skill or labor or hard work in the presentation, in the better or different presentation of the same idea that you have got. So that is what will get you the copyright, what will get you the bundle of rights that are provided under the copyright law. Original presentation of an idea which might already be there. The idea may be old, but the presentation shall be new. Only then the person will get the copyright. Now again, I'll come back to so these are two things. So you don't need to register it mandatorily, and the idea will not get you the copyright. You cannot get the idea registered. You have to get the presentation registered with the registrar of copyright. Now we were talking about classes of work. So classes of work, literally, as I said, dramatic, musical, cinematographic film, artistic work. Artist, some painting, some sculpture, some work of architecture, artistic craftsmanship. So if we talk about sand artists, so when in 1957, when the Copyright Act was passed, there was no sand artist. Now we have sand artist also. Very recently, I came across a reel that talked about ceramic artists. So a person who is making different things from ceramics. He or she is also an artist, will be covered under the copyright, under the artistic work. Okay? So whenever there is some art involved, that will be an artistic work. Cinematographic films, we all know what is a cinematographic film. So whenever there is a visual recording on any medium, that can be on a camera, that can be on a phone. So moving images are there. That is cinematographic film. That will also get you the copyright. Musical work, any work that consists of music and includes graphical notation. Now we have musical work as well as sound recording. Musical work is the music, the sound, as well as the graphical notation. If you people have ever seen people singing, so they have these notes in front of them, and their sur and tal goes according to those notes. So those graphical notation will also be covered under copyright law. Then we have sound recording, where we don't have the notation, but we have the sound recording. So beatboxing, if you people are aware of, so beatboxing, they don't have the notations or the words, but they have that sound that's coming out. So that will get copyright and the rights, bundle of rights that are provided there, so under copyright law. Cinematographic film. Then we also have government works and Indian works, though they are not the classes of work that will get you the copyright, but they are defined under copyright law that whenever any work is created by a government employee, that will be government work, and whenever any work is so this we need to know about government work and Indian work because we need to know about the ownership and authorship and the term of copyright. So we need to understand what is a government work or what is an Indian work. So if a person is citizen of India or the work is first published in India, that will be a Indian work. So till now, meaning of copyright, that means a person has a right to copy, exclusive right to copy his work, or right to allow others to copy his work. Now, we'll talk about that assignment also. So, to uh, one meaning is a bundle of rights that are provided under any creation of mind, that is literary, dramatic, musical, or artistic work, right? And those rights include right to reproduction, communication, adaptation, and translation. This I'm going to discuss later. So the classes of work: literary work, dramatic work, musical work, artistic work, cinematographic film, sound recording. And as I told you that there was an amendment in 2012 in Copyright Act, so now the performers are also allowed some rights under Copyright Act, and as well as broadcasters like whenever any movie is broadcasted on Netflix पे हम movies देखते हैं, broadcast कर रहे हैं performance, we all know है ना, we all know कि performances क्या होती हैं, a person singing, a person dancing or performing his or her art, all these are uh, performers under the Copyright Act. Now, before talking about the authorship and ownership, I'll also talk about the rights. So, as per Copyright Act, we will get two kinds of right under. As I said, it is not mandatory to get copyright registered. But again, I'll insist that registration shall be done, because if there is any dispute, it is easy to prove if it is registered. Abhi, if you people sometimes go to news channel, I don't go to news channels, go to newspapers. So at times, people say, उसने मेरा गाना चुरा लिया, उसने मेरा आइडिया चुरा लिया मूवी बनाने का, है ना? चोरी कैसे हो गया गाना, या फिर आपका आइडिया कोई कैसे चोरी कर सकता है? That can be only done if it is published. मैंने जैसे आपको बताया कि आइडिया है, एक आइडिया के ऊपर आपको कॉपीराइट नहीं मिला है, दैट आइडिया कैन बी प्रेजेंटेड इन सेपरेट वेज, डिफरेंट वेज. एनीवन आप में से कोई अनु मलिक को जानता हो? एवर हर्ड ऑफ? So Anu Malik generally says, when he copies English songs, he generally says कि मैं तो inspired हूँ, though he copies them as it is. But then there are few things that he changes and then he get the copyright. Reason being, copyright जो है ना, आप उसमें थोड़ी सी भी changes कर दें. Like if we take the example of these dictionaries, Oxford dictionary के पास अपना copyright है, Cambridge की dictionary के पास अपना copyright है. They are presenting the same information. They are the dictionaries, but the way they have accumulated that information, the way they have presented that information is different. So whenever you have put in some hard work or some skill or labor while presenting your work, you'll get the copyright. मैं ऑक्सफोर्ड की डिक्शनरी का कॉपीराइट ले लूंगी, आप कैम्ब्रिज की ले लोगे, बिकॉज द प्रेजेंटेशन इज डिफरेंट फ्रॉम ईच अदर. Okay, so classes of work ho gaya, sound recording, artistic and other things. Now talking about the rights that we get under the copyright. Now, as per the copyright law, we get two kinds of rights under the copyright whenever I apply for a copyright. So, I'm sorry, I was talking about this चोरी हो गया. चोरी हो गया आप कैसे prove करेंगे? Only if you have that song, the notations of those songs or lyrics of that song registered in your name. Only then you can prove कि ये मेरा गाना था जो चोरी हो गया. आपने अपना song लिखा, उसे अपने घर पे रख लिया. सेम चीजें मैंने लिख के उसको रजिस्टर करा लिया. So obviously I'll in a better position to prove that these rights belong to me rather than you who don't have the registration of that copyright. So it is not mandatory, but it is always advisable to get the this register. You just have to apply to the registrar, and that you'll get the registration in your name. So now kinds of rights. So there are two kinds of rights that are provided under kinds of right. I'm not talking about different rights. These are two kinds of rights that are given under copyright. One is economic rights, second is moral right. Economic rights, as it shows, that is related to money. So in all the original literary, dramatic, musical work, there are few rights that are provided. That will fetch you money. That will be considered as economic rights. like to reproduce the work. So if I have sung a song, I'll release the albums, or I'll release the song on Netflix, I'll release the song on Spotify. That will be reproduction. I'll publish my work, I'll share the work with the public, I'll sing it, I'll perform it. You know, वर्क को पब्लिश करना और उसको पब्लिक में परफॉर्म करना, दैट इज योर राइट. दीज आर द राइट्स दैट विल फेच द मनी. अगर मैं एल्बम रिलीज करती हूँ, people will buy the rights, will pay me. Those are the economic rights. If I'm going to perform, people will buy the tickets. That is economic rights. I have the right to produce, reproduce, perform, and publish the rights. Also, I have the right to produce, reproduce, perform, publish translation of that work. ठीक है, तो ट्रांसलेशन एज वेल एज द ओरिजिनल वर्क, इन सबको ट्रांसलेशन फ्रॉम हिंदी टू इंग्लिश, इंग्लिश टू हिंदी टू तमिल. आजकल सब नेटफ्लिक्स पे तमिल और मलयालम एंड ऑल दोस तेलुगु मूवीज आर रिलीज्ड in Tamil as well as Hindi, Telugu, Hindi, and other languages also. Tamil movie is released in Telugu language also. So if a movie is produced by Netflix, so Netflix has the right to publish it. The people who are there with the permission of the producer has the right to perform that. They have the right, Netflix has the right to reproduce that, and also to reproduce, produce, perform, and publish the translation of that work. That is one right. Then to communicate it to the people. Now we also have two moral rights. So under copyright law, I can transfer my economic rights to another person. I can give this right to publish my work to another person for a certain amount of money. That can be paid monthly or royalty. If we talk about publication or transfer of rights, so I'll take the example of a book. I have written a book, I'm the author. I give this right that is given to me by the copyright law to any publisher, that I don't want to publish it, you publish it and you take 50% and and pay me the rest of the 50%. So I'll get the money, that is my economic right, and I can transfer that right to some other person, to the publisher who will publish the book and earn from my work. So right was all mine. I have kept few rights with me and other right I have transferred. I have a right to reproduce. I have a right to publish. I gave the right to publish to another person, and I kept the right to say it is a poem. I kept the right to recite that poem with me, and I gave the right to publish to another person. I transferred it for money. Okay. Moral right में क्या होगा? There are two rights that are covered under moral rights. So one is right to paternity and second is right to integrity. Now, right to paternity is, though I have transferred my rights to another person, मैंने बुक लिखी, उसको पब्लिश करने का राइट मैंने पब्लिशर को दे दिया, but the author of that book will always be me. The publisher cannot be author. So right to paternity means to own that thing, to be the parent of that thing. I have written, I have created that thing. I am the parent. So the paternity right will always be with me. I'll be always the author. No one, I can transfer all my rights, but I cannot transfer this right of being the author of that work to another person. Reason being, I have created, I'll always be the mother or the father. That right I cannot transfer. I'll marry off my daughter, I'll marry off my son, but they will never get this right. I can never transfer this right of being mother or father to another person. So whenever I create a book, I write an article, I write a poem, I create a song, I'll always be the creator. I can transfer the right to earn from that work, but the creator, the inventor, the author will always be me. Okay? One thing. Second, right to integrity. Right to integrity, moral right. These two rights are the rights which cannot be transferred, and that these rights are not going to fetch any money. You cannot earn through these rights, but these rights will always belong to that person. Right to paternity, to be called the author, to be called the creator, that no one can take from me. And right of integrity. I have this right that no one is going to damage my work that will further damage the reputation. So if a person is copying my article and presenting it in a very awful manner, in that case, I have this right of integrity that I can challenge. A person, even if I have transferred my right to publish, a person cannot make the changes while publishing that it will damage my reputation or my work. If my work is being damaged, I can always challenge, though I have transferred my right to the other person, but that right to integrity will always remain with me. Reason being, I am the author, I am the parent of that work. I will never take the deterioration of my work by any person. So that these two moral rights are always with me. Other rights, economic rights, that talk about reproduction, that talk about translation, that talk about adaptation, all those rights can be transferred to another person. Now these economic rights, so right to reproduce the work, right to communicate it to the public, right to perform, right to issue works, right to translate, right to adaptation. Now what is adaptation? So I wrote a movie, as आप सबने देखा होगा, थ्री इडियट्स, चेतन भगत की मूवी थी, थ्री मिस्टेक्स ऑफ माई लाइफ, उसके ऊपर काय पोछे बन गई. So that is adaptation. When a work, adaptation means when a non-dramatic work is converted into dramatic work, or when a dramatic work is converted into a non-dramatic work. So movie to book and book to movie. That is adaptation. That right is economic right. So Chetan Bhagat transferred his right of adaptation to T series or Sony, and they made the movie. So if you people are aware of Three Idiots, so that is based on the book written by Chetan Bhagat. Now, he claimed that he has not been given the proper credit. So generally, what happens is, whenever Harry Potter, everyone knows, so that is adaptation from the book of J.K. Rowling to the movies series of movie that is made on Harry Potter. So all these are adaptation. These are economic rights, so it can be transferred. We all know the story of J.K. Rowling. Kaise she was like, she had thought of committing suicide, but now she has earned so much from that. So that is an economic right, adaptation. I have this right. I can make a movie on my book, or I can authorize someone else to make a movie on my book, or I have made a movie and it was a super hit, and someone wants to write a book on that. So I can transfer that right of adaptation to another person, that, okay, this is the story. You want to write a book? You can write a book on that. So that adaptation right is economic right, which is given to another person. Translation. So all these rights are given in literary, dramatic, and musical works. Am I audible? Dia?
Yes, ma'am.
Yes, ma'am.
Okay, okay. I'm sorry, there was a call in. Okay, artistic as well as musical work, as well as cinematographic films, as well as sound recording. Okay? So right to reproduce, right to communicate, right to adapt, all these rights are available in these kind of rights. But it shall be original. Original work will get the rights, otherwise no right is given. So even in artistic work, you can make the adaptation. Like artistic work में अगर मैं ताजमहल की example लूँ, so that is an artistic work. Nobody knows the story behind it, but we have heard of it, and there are few movies on that. So that is adaptation, a kind of adaptation. Cinematographic film, any record, all these are uh, economic and moral rights. Now talking about, so I kept on saying author, author, author. So as per Copyright Act, there can be two persons. One can be the author of the work, another is owner. Generally, a person, the first owner will always be the author. A person who has written a book, a person who has made the movie, a person who has written an article, that person is the owner or author of the rights. Okay. So, but as I said, there are few rights, economic rights, that can be transferred. So the person to whom the right is transferred becomes the owner. So I wrote a book, I am the author of that. And I transferred the right of publication of that book to another person. That person becomes the owner of the of that copyright. Author and owner, two rights the right of paternity and right of integrity that always belongs to the author. If I have written a book, if I have written an article, if I have written lyrics of a song, if I have made a music, the musical work की अगर हम बात करें, if I had done something that has artistic, artistic side, that is artistic work. I have created, I am the author. I will be the first author. I can always remain the author as well as owner. But yes, of course, there are economic rights which can be transferred. So I'll take the example of a movie. So जितनी भी films होती हैं, so there is a person, hero, heroine, villain. They don't have any right. They get the payment. They have the performers' rights, obviously, but not. They are not the owner of copyright in a movie. Copyright in a movie belongs to the producer of that movie. Reason being, the producer has paid to all the persons and जैसे कहते हैं ना कंपाइल करके उन्होंने एक मूवी बना दी. So the producer pays to the music director, to the lyricist of the song, to the choreographer, to the hero, actor, actress, villain, character artist, costume designer, and all the other people. So he is the owner. Everyone has a copyright. In a musical work, in a song, जितने भी movies में songs होते हैं, there are two copyrights. One belongs to the person who has created the music, another belongs to the person who has written the song. They are the authors of the copyright. Now they transfer that, these two people transfer that right to the producer. कि आप हमें पैसे दे दो, this amount, certain amount जितना भी उन लोगों का रहता है, this amount you pay us, and then he'll pay, and the producer becomes the owner. Author will always will be the person who has created that, who has created that work, who has created the music, who has written those words, who has written those lyrics. They'll always be the author, but the owner is another person to whom the right is transferred. First right of being the owner first owner will always be the author of that work. But if the economic rights are transferred to another person, that person will become the owner of the copyright. He's not the author. They are two different people. These are two different terms. Author who created, owner to whom the rights are transferred. Economic rights, when they are transferred, they belong to the owner of the copyright. So that is authorship and ownership. So first owner, as I said, will always be the author. And in case of literary, dramatic, artistic work, the author. Now, there are a few other things also when we talk about authorship and ownership. So if a person who is creating a work, a work that he wants to claim copyright in, now that person, if he is in an employment, जैसे हमने government work की बात करी. So if a person who is in government service, he creates some work. So that is these clauses are always there in the agreements that are signed while joining a job, whether it's a government job or a private job. What happens is these clauses are there in the employment agreements generally these days. So if I create a work while I am an employee of the private or the government sector, the copyright will belong to the employer. I'll be the author. Owner will be the employer. Right? So these clauses are there. But then there is another restriction on this, that if the work is part of my employment, only then that person will be the owner. So say I'm into teaching, right? If I create some notes, the copyright will belong to the employer if that clause is there in the employment agreement. But if this is something outside, so I am a teacher, but I am writing a song, that is not part of my employment. Or I am creating some musical work, I'm creating some music, or say I'm making a movie, I'm producing a movie, or I am doing some artistic work. In all these cases, the copyright, the ownership, the authorship will belong to me, whether I'm employee of that any government sector or private sector. The clause is there. that whenever any work is created during the employment, that copyright will belong to my employer. But that shall be within the course of employment as we study in the vicarious liability concept. If it is outside the course of employment, I'll be the author, I'll be the owner. If it is within the course of employment, I'll be the author, my employer will be the owner. So economic rights will belong to the employer, and moral rights will always belong to the author, that is me. So in any work, so if I have written an article for a newspaper, I'm the employee of a newspaper. In that case, the copyright will belong to the owner of the newspaper, not to me. I'm the author only. So writing an article for the newspaper is within the employment of my within the course of my employment. So the copyright will belong to the person who is um, who is the owner of the copyright. Now, one thing that I have missed in all these is the photographs. Photography is, of course, it is covered under the artistic work. So photographs, though we have studied this in detail in our classes, you all must have done that. So we all are aware of monkey selfie case. So earlier, the person who used to take as per the copyright law, the person who clicks the photograph is the owner of the photograph. ठीक है, मैंने क्लिक करी, मैं ऑनर हो, आपने क्लिक करी, आप ऑनर हो. So in that monkey selfie case, so one of the photographer, very famous photographer, he had put in the camera on a stand. He didn't click the picture. So he wanted a particular, expression on the face of the animal. So he wanted that photograph, that particular photograph. So what he did was he put his camera on the stand, and a monkey came. Monkey clicked the selfie. Now there was a dispute. Earlier it was everything was fine, but then when the photograph was published on Wikipedia and when the money came in, the economic part of it came in, so the caretaker of that monkey, he came up that monkey is the owner of that photograph. Now how monkey can be owner of a photograph? But as per the copyright law, whoever clicks the picture is the owner of the copyright. So as per the law, if we go by the interpretation of the law, literal interpretation, in that case, the monkey is the owner of the photograph. But monkey cannot be the owner of the photograph. So there was this dispute and आगे फिर litigation हुआ, and then after there was a compromise after that whatever the photograph is going to earn from that selfie, 25% of that earning will go to the place where that monkey was being taken care of. So in a way, this is my interpretation. In a way, the monkey was held honor of 25% of that right. So जितने भी मेरे पास right हैं, the picture was clicked from my camera. I was the owner of the camera, but I didn't click the picture. So law तो यही कह रहा है कि जिसने picture click किया, that person will be the owner. But since it was an animal who cannot be termed as owner, so एक compromise किया गया. But as per the compromise, अगर हम interpret करें, so 25% of the work belong to the monkey and 75% to the photographer. So photographer will be the person who clicks the photograph will be the owner. Okay. Now talking about term of copyright. So generally, the one thing that we shall keep in mind is there are two things. So one common thing is term of copyright. Now, okay, I'll again take an example of movies as well as these songs. So there are many songs these days. I don't know. I think you all are from different areas of our country, but Punjabi song I think सब जगह चल रहे हैं फिलहाल के लिए. ठीक है? So the not only Punjabi, all the folk songs, they are getting their they're getting the exposure in the movies now. So what they do is they change the beat, they take the words और रीमिक्स होता है. जैसे पुराने सॉन्ग्स लेते हैं, उसका थोड़ा बीट चेंज करते हैं, उसको नई मूवी में नए म्यूजिक के साथ ऐड ऑन कर देते हैं. ठीक है? So that is, you are using the work of another person. Now can we do that? अब with permission you can do that. Now what happens is, so folk song क्या है, हमारे बहुत पुराने songs, उनको हम यूज क्यों कर सकते हैं? those words can be used. Why they can be used? Because the copyright in those things have already expired. Because copyright is one, so we have trademark जो हमेशा के लिए रहता है. Rights provided by the registration of a trademark are the lifetime wala rights. But rights under patents, design, copyright, these rights are for limited time period. As per Copyright Act 1957, the rights under copyright, the bundle of rights that are given under copyright, they will be there till 60 years plus lifetime of the person. So if I have written a book after my death, 16 years, that will be counted from the next year of my death. So if I die, so suppose I have written a book in 19, not 19, so in 2020, I die in 2025. So 26 onwards, 60 years will be the term of copyright. After 60 years, every person on this earth is free to use the work created by me. So जो हमारे फोक सॉन्ग्स हैं बहुत पुराने हैं, उनके जो कॉपीराइट अगर उस टाइम पर लिए भी नहीं जाते थे, लिए भी जाते तो बाय दिस टाइम दे आर ओवर. So if the creator of the work is alive, in that case, lifetime plus 60 years, the person will be the owner and the author of his or her own work. After that, that is open, people can use that work. Plus, if a person is not alive, so I don't know who is the author of the song, folk song की बात करते हैं, हमें पता ही नहीं है किसने लिखे थे, ठीक है? Those songs are being sung time and again, time and again, time and again. Now, if the person is not known, or if the work is something like it's a movie में हम author की बात नहीं करते हैं, or it's a dramatic work, or it's an artistic work, in that case, the time period still will be 60 years, but those 60 years will be counted from the date of publication. So the day a movie releases, from that day, उससे next year वाले में count करके till 60 years, the copyright belongs to the person who has produced that movie. After that, it is open to be copied by, though there are some provisions for this. So after that, any person can use that work. So for literary, dramatic, musical, artistic work, other than a photograph, if it is published during the lifetime of author, then 60 years from the beginning of the calendar year next following the year in which the author dies, lifetime, or in which the work is first published if the author is not known, या फिर एक ऐसा पर्सन है जिसने या तो anonymous है, हमें पता ही नहीं है किसने बनाया है, या तो a person who is using a name, जैसे वो कहते हैं ना तकिया कलाम, सब ना तकिया कलाम the common name, authors या शायर यूज करते हैं जैसे अपने वर्ड्स के साथ पीछे लगा लिया. So Diljit Dosanjh is the name of his village. Sidhu Musewala is the name of his village. Sahir Ludhianvi, all these Allahabadi. So all these are their pseudonyms that they are using. So that in that case, when the work was first published, from that till 60 years. Now posthumous work. If the work was published after the death of the person, again 60 years from the beginning of the calendar next the year in which the work was first published, that date. Cinematographic films or records हम सबको पता है क्या होते हैं, again 60 years next following the year in which the film was or the record was published. So all these get the protection under copyright till 60 years from the date of first publication. Okay, so now these rights, as I said, there are two kinds of right. There are economic rights, there are moral rights. Economic rights can be transferred through assignment. So My wish, I want to transfer my rights, economic rights, to another person. So I can, in writing, I have to do this in writing. I can assign that work to another person through a written document, and that person will get the rights. Another way of transfer of these rights under copyright is license. When a person is given license, can be compulsory license also. So if a person is keeping the work to himself, or just a book set, so there is a book that is beneficial for the students in that case, or beneficial for any part of society. So in that case, I'm not going to publish. So मैंने 10 books publish करी, उसके बाद मैं publish ही नहीं कर रही हूँ कि मुझे नहीं करना है. In that case, government can, the registrar and the comptroller general, they can grant compulsory license, where I'll apply for the license, that this, so I'll prove that this work is for benefit of the society, and the author is not communicating this work to the public. In that case, the government, in consultation with the registrar and the controller general, जो कि government को represent कर रहे हैं in cases में, so that person will grant me the license, and I'll get the license to publish that book. So my rights will be transferred. My right to publish will be transferred to the person who is getting the compulsory license. So these are two modes through which we can transfer our economic rights to another person. These are two modes, jahan pe assignment and license. So I can assign according to my terms and conditions, according to my wish, through a written document, or a compulsory license can be granted by the government that the work shall be published or performed, so that uh, the, the society on whole can get the benefit from the work. Okay. Uh, okay. Next, we'll talk about the infringement of copyright. Dia,
Yes, ma'am.
I'll take a break of 2 minutes only. Yeah.
No issues, ma'am.
Hanji. So I was talking about infringement now. Now, what is an infringement? As you all might be aware of this, infringement is breach of a right. अगर हम से simple terms में बोले, so whatever right I had, if you are exercising those rights without my permission, that will be called as infringement. So Section 51 to 53 of Copyright Act talks about infringement. So it says violation, piracy, or theft of copyright holders' exclusive rights. So if I'm the author or I'm the owner, I have few rights, as we have discussed, economic as well as moral rights. So if any person violates any of my exclusive right, and there is unauthorized use of my copyrighted work, that will be infringement of my copyright. Unauthorized use of a work, unauthorized reproduction, unauthorized distribution, unauthorized performance, unauthorized publication, unauthorized translation, unauthorized adaptation, unauthorized transfer of my right without my permission. If all these things are done, that will be termed as infringement of my right. See, so Copyright Act has given exclusive rights to me, and if you are using those rights, that will amount to infringement of my copyright. Yeah. So unauthorized, I am the exclusive owner of those rights. I am the person who has been granted rights under that, under the law. And you are using my rights. Whatever I am authorized to do, you are doing that without my permission, without my authorization. That will amount to violation of my right. So that will be infringement. So I have right of reproduction. तो जैसे हम फोटो कॉपी करवा लेते हैं बुक्स को, so though that is an exception, photocopy of the book is not infringement of copyright ना, वो हम अभी पढ़ेंगे, there are few exceptions. So मेरी लिखी बुक पे आपने विदाउट माय परमिशन एक मूवी बना दी, that will be unauthorized adaptation, that is infringement of my copyright. आई हैव रिटन अ बुक इन इंग्लिश, आपने उसको हिंदी में ट्रांसलेट कर दिया और आपने उसको फ्रेंच, जर्मन, किसी भी लैंग्वेज में ट्रांसलेट कर दिया, दैट विल अमाउंट टू infringement of my copyright. That is violation of rights given to me, exclusively to me, as the author or the owner of copyright. You adapted my work, you translated my work, आपने मेरा वर्क ट्रांसफर कर दिया without my permission. So I had written a book which I shared with you. पब्लिश किया गया. So ना publication जैसे publication भी और sharing और communication of the work with any person. The basic thing is it shall come out, it shall not remain with me. तो अगर मैंने उसको say students के साथ share किया and someone get it published in their own name, that will amount to infringement of my work. मैंने एक म्यूजिकल वर्क क्रिएट किया, आपने उसको विदाउट माय परमिशन अपनी मूवी में ऐड कर दिया, दैट विल अमाउंट टू इन्फ्रिंजमेंट ऑफ माय राइट्स. आपने पब्लिकेशन कर दिया, परफॉर्म कर दिया, ऑल दीज विल विदाउट माय परमिशन. इफ इट इज विद माय परमिशन, आई हैव ट्रांसफर्ड द राइट्स टू यू, but if it is without permission, that is unauthorized, that will amount to infringement of my rights, where you are using those, you are doing those acts, or you are using those rights which are exclusively given to me. Distribute kar diya, import kar diya. So my friend from America was coming into India. मैंने आपने मुझे बुक पढ़ने के लिए दी थी, मैंने उसको कॉपी करवाया दो चार, एंड आई गिव इट टू दैट पर्सन, और उसने अमेरिका में जाके उसको पब्लिश करवा दिया. दैट विल अमाउंट टू इन्फ्रिंजमेंट. इन्फ्रिंजिंग कॉपीज बनाने के लिए अगर आप इक्विपमेंट रख रहे हो, दैट विल ऑल्सो अमाउंट टू इन्फ्रिंजमेंट ऑफ राइट्स. सो यू हैव दिस आर्टिस्टिक वर्क के लिए अगर हम एग्जाम्पल लें, मैं जो भी वर्क क्रिएट कर रही हूँ, आपने ऐसे मोल्ड्स बना रखे हैं, ले रखे हैं कि आप उससे मेरा वर्क कॉपी करके उसको से publish in your own name, that this work was created by me, that will amount to infringement, because I have not authorized you to do that. That right belongs exclusively to me, and you are using those molds to create work like my work, or creating this confusion that this work is created by you, so that will amount to infringement. Also, any work that is created by me, if you sell that work or if you give that work on rent, उसे डिस्प्ले कर रहे हैं, सेल के लिए ऑफर कर रहे हैं, हायर के लिए ऑफर कर रहे हैं, all these acts will also amount to infringement of copyright. If you are allowing your place, your premises to be used for infringement so that you can earn from that. So a person is infringing my rights and you are helping that person through renting out, or without rent you are giving your place that okay, you can do the work here, you can work, you can copy my work sitting there in your house. If you allow that, that will also amount to infringement. आप किसी भी तरह से पब्लिक में एग्जिबिट कर लें without my permission, all these acts will be counted as infringement because these are my rights which you are using. Infringing copies बनाना, उसको distribute करना, public में exhibit करना, अपने place को use करने देना, import करना, infringing copies को, all these will amount to infringement under copyright law. Okay. Now, before moving on to the remedies, there are few exceptions that are there when it will not be counted as infringement. Few of the acts which are given here will, which we understand as infringement, will not be counted as infringement. So there are few exceptions to that. The first exception in that is fair dealing, fair use. A fair use क्या है? So it's a concept where the work is being used fairly by one. You are not saying that this is your work. Fair enough. I have written a book. आप कह रहे हैं कि ये मनीषा की बुक है, इसे पढ़ लीजिए. Obviously, that is not infringement. ठीक है? Now, fair dealing is a limitation that is a limitation on my exclusive right. If a person is fairly using my work as provided by the law, that will not amount to infringement. So, if a person is using my work for exclusively only for research purposes, that will amount to fair use. That will not be counted as infringement. ठीक है? तो आपने मेरा कोई आर्टिकल लिया, उसको पढ़ा, उसमें से कुछ वर्ड्स यू कॉपीड एंड अदर्स आपने बाकी अपने आप लिखा, दैट विल नॉट अमाउंट टू infringement of my exclusive right. If you are using that work for criticism and review purpose, हम book review करते हैं, आप मेरे work को criticize करना चाहते हैं that this book is not as per the requirements or it is not updated book. So for the purpose of criticism and for the purpose of review, if you are using my work. So जैसे हम again I'll take the example of movies. So movie critics होते हैं. So वो सारी मूवी की बात करते हैं. At times they talk about the particular scenes also. उसको review और criticize करने के लिए criticize करें, उसको review करना है. In that case also, that will not amount to infringement of copyright. Number 3 under fair dealing is if those things are being used for reporting purpose. So there is a public event. Suppose आज के lecture की अगर हम बात करें. So if a person is writing a report and using whatever I have been saying, मैंने एक exclusive example ली सोचो. So that is my original creativity. In that case, you are not supposed to do that. मैंने आपको communicate कर दिया. But अगर आप रिपोर्ट के पर्पस के लिए whatever I have said आप उसको verbatim use करते हैं, in that case also that will be fair use and it will not amount to infringement of my copyright, of my exclusive rights. If the work is being reproduced for reporting in any judicial proceeding, कोर्ट में से जैसे हमारे जो जजेस होते हैं, हमारे जितने भी जुडिशरी में हैं, स्पेसिफिकली हाई कोर्ट एंड सुप्रीम कोर्ट जजेस, दे ऑफन यूज एग्जांपल्स एंड कोट्स फ्रॉम डिफरेंट वर्क्स, लिटरेरी वर्क्स, एट टाइम्स बुक्स में से कुछ कोट्स लेते हैं. सो दैट विल नॉट अमाउंट टू infringement of my copyright literary work since it is being reproduced for the judicial purposes. Reproduction or publication for a work prepared by Secretariat of Legislature. So हमारे गैजेट ऑफ इंडिया में वेरैक्स आते हैं, हमारे लॉज जो भी पास होते हैं, अगर मैं उसको रिप्रोड्यूस कर रही हूँ, दैट विल नॉट अमाउंट टू infringement of the copyright, as it is a fair use of the work that is done by the Secretariat of the Legislature. For reproduction of any work in a certified copy made or supplied according to the law. लॉ ने आपको अलाउ किया है सर्टिफाइड कॉपी इशू करना, आप वो सर्टिफाइड कॉपी इशू कर रहे हैं, इन दैट केस वो रिप्रोडक्शन विल नॉट अमाउंट टू इन्फ्रिंजमेंट. रीडिंग और एनी लिटरेरी और ड्रामेटिक वर्क इन पब्लिक डोमेन. सो से म्यूजिक इज रिलीज, है ना, कितने सारे सॉन्ग्स रिलीज होते हैं, हम उसे जैसे आपकी घर की आपकी पार्टीज होती हैं प्राइवेट यूज के लिए, दैट विल नॉट काउंट एज इन्फ्रिंजमेंट. आप कॉलेज में अपने कैंपस में अपने डिपार्टमेंट में आपको कोई फंक्शन हो रहा है, वो सॉन्ग्स यू आर सिंगिंग दैट सॉन्ग, दैट विल नॉट अमाउंट टू इन्फ्रिंजमेंट ऑफ कॉपीराइट ऑफ द प्रोड्यूसर और द लिरिसिस्ट और द पर्सन हु हैज क्रिएटेड दैट म्यूजिक. ठीक है. सो पब्लिक डोमेन में अगर आप कोई भी रेसिटेशन रिसाइट कर रहे हैं पोएम को या कोई ड्रामेटिक वर्क को, दैट विल नॉट अमाउंट टू इन्फ्रिंजमेंट. Any non-copyright matter that is for being used by the educational institution for the purpose of education, that will also not amount to infringement. कहीं भी अगर आप प्राइवेट में किसी भी कॉपीराइटेड वर्क को यूज कर रहे हैं, अगेन दैट विल नॉट अमाउंट टू इन्फ्रिंजमेंट. दैट इज कंसिडर्ड टू बी अ fair dealing of the copyrighted work. Also, when we talk about literary work, so publication and collection mainly composed of bona fide use in education purpose. If any literary work is kept in a library and there are 3 copies of that work that are there in the library, that will not amount to infringement of copyright. ठीक है. किसी भी ऑथर के वर्क से अगर आप एजुकेशन पर्पस के लिए कुछ भी कॉपी कर रहे हैं, नॉट मोर देन 2 पैसेजेस फ्रॉम द वर्क शैल बी टेकन. अगर आप लेस देन 2 पैसेजेस कॉपी कर रहे हो, दैट विल नॉट अमाउंट टू इन्फ्रिंजमेंट. देयर आर फ्यू कंडीशंस ऑन दैट आल्सो. ठीक है. 3 कॉपीज जैसे मैंने आपको बताया पब्लिक लाइब्रेरी में रख रहे हैं, इन दैट केस आल्सो इफ यू आर यूजिंग इट फॉर प्राइवेट स्टडी, in that case also it will not amount to infringement. Official gazette में जो act of legislature publish होते हैं, that will not amount to infringement. किसी भी कोर्ट, ट्राइब्यूनल और जुडिशियल अथॉरिटी की जजमेंट को रिप्रोड्यूस करना will not amount to infringement unless it is prohibited by the court, tribunal or judicial authority. Any report of any committee, commission, council, board or any body appointed by the court will not amount to infringement. Reproduction, publication of a translation in any Indian language of any act. So we all have been studying IPC. Now अचानक से BNS आ गया है. We are not able to understand. So to help students to understand it in an easy way, if the government allows the translation, in that case that will not amount to infringement of copyright. ठीक है. किसी भी cinematographic film में किसी भी artistic work which is permanently situated in public place or premises where generally public can go, so Taj Mahal के लिए though they need the permission, but in case there is an artistic work which is in public place or where the public has access, उसको cinematographic film में include करना will not amount to infringement of rights as provided by the Copyright Act. किसी भी ऑब्जेक्ट को the object artistic work के केस में making of an object of any description in 3 dimensions which was actually earlier in 2 dimensions, that will not amount to infringement of the copyright as provided in the Copyright Act. Reconstruction of a building or structure according to the architectural drawings or plans will not amount to infringement. Also, if a literary, dramatic, or musical work is reproduced in a cinematographic film. So there is a musical work, एक song है जो कि cinematographic film में है. उस वर्क, उस सॉन्ग को, उस म्यूजिकल वर्क को या फिर ड्रामेटिक वर्क का, द एग्जीबिशन ऑफ दैट मूवी आफ्टर द एक्सपायरेशन ऑफ टर्म विल नॉट अमाउंट टू infringement of copyright. So there, so generally we take it. So any work, any act that is done which I was authorized is done without my permission or without my authorization, that will amount to infringement. But then there are exceptions that are provided in the Copyright Act itself that says that if these acts are committed in these situations, that will not amount to infringement of copyright. The biggest in that is fair dealing. So if you are reproducing that work for research purpose or private study, or it is being produced so that it can be criticized or reviewed, or it is being produced in any judicial proceeding, that will not amount to infringement. Literary work, dramatic work, musical work, इसका reproduction हो रहा है for research, private में हो रहा है. If I'm singing a song in private, that will not amount to infringement of copyright of the producer. If a movie or मुझे Netflix की movie देखनी है ना? मैंने सब्सक्रिप्शन ले रखा है. So the moment I buy that subscription, I get this right to publish that. अब वो मैं अपने फ्रेंड्स को बुला के दिखाऊं Netflix पे, मैं अपनी पूरी फैमिली को इकट्ठा करके दिखा दूं. The moment copyright, कोई भी मूवी होगी ना, उसका copyright will belong to the person, the producer. ठीक है, उसके पास ट्रांसफर हो गए. सो म्यूजिक का राइट, लिरिक्स जो लिरिसिस्ट है उसके राइट, म्यूजिक डायरेक्टर के राइट्स, ऑल दीज आर ट्रांसफर टू द प्रोड्यूसर. प्रोड्यूसर हैज सोल्ड दोज द राइट, अगेन इकोनॉमिक राइट ऑफ पब्लिकेशन, ऑफ कम्युनिकेशन टू द पब्लिक, टू नेटफ्लिक्स. ठीक है, या फिर थिएटर ऑनर जो भी पीवीआर है या जिन्होंने भी उसको बाय किया. मैंने, I am the person who has created the music, or I am the person who has written the lyrics, or I am the person who has written the story of that movie, script writer. हमने सबने अपने राइट ट्रांसफर किए प्रोड्यूसर को. प्रोड्यूसर becomes the owner of that copyright. प्रोड्यूसर ने फर्दर उसको पब्लिश करने का राइट या परफॉर्म करने का राइट, कम्युनिकेट करने का राइट दे दिया नेटफ्लिक्स को. नेटफ्लिक्स ने फर्दर राइट्स प्रोवाइड कर दिए मुझे. हाउ? व्हेन आई अप्लाई फॉर द सब्सक्रिप्शन. अब मूवी देखने जाते हैं, थिएटर में पे करते हैं, यू हैव पेड फॉर दैट लिमिटेड राइट. मैंने नेटफ्लिक्स की जब सब्सक्रिप्शन ली, मेरे पास सिर्फ एक राइट आया, दैट आई कैन शेयर और आई कैन पब्लिश दैट वर्क टू द पब्लिक, टू द पीपल हु आर अराउंड मी. सो आई गॉट द लिमिटेड राइट ऑफ पब्लिशिंग दैट वर्क टू द पब्लिक और कम्युनिकेटिंग दैट वर्क टू द पब्लिक. सो सबको अकॉर्डिंगली लिमिटेड राइट्स जो है वो ट्रांसफर हो गए. आई एम ऑथोराइज्ड. बट इफ विदाउट द परमिशन, विदाउट नेटफ्लिक्स की जैसे सब्सक्रिप्शन होती है, बिना सब्सक्रिप्शन के मैं किसी तरह से हैक कर लूं नेटफ्लिक्स का सर्वर, दो इट इज नॉट पॉसिबल. दिस इज समथिंग विच इज इम्पॉसिबल टू डू. सो मैं कर लेती हूँ. That will amount to infringement क्योंकि मैं authorized नहीं हूँ. But infringement के भी कुछ exceptions हैं, जैसे हमने बात की. So criticism and review के लिए, report करने के लिए, private study के लिए, research के लिए. Literary work की बात करूँ तो library में 3 books रखी हैं, 3 copies are there. In that case, that will not amount to infringement. अगर मैंने उस एक artistic work है which is permanently situated in a public place, उसको मैं cinematographic film में दिखा देती हूँ, that will not amount to. So mountains में जा रहे हैं, public place है, मैं ये नहीं कह सकती कि से माउंट एवरेस्ट को मैं नहीं दिखा सकती अपनी मूवी में, that will not amount to infringement. माउंट एवरेस्ट खैर वर्क भी नहीं है, otherwise also. जितने भी हैं, अब जैसे ताजमहल है, उसके लिए परमिशन क्यों लेनी पड़ती है? उसको हम कंजर्व करना चाह रहे हैं, इट इज डिटीरियोरेटिंग डे बाय डे। सो उसकी कंजर्वेशन के लिए, उसकी प्रोटेक्शन के लिए हमने ये रूल बना दिया कि अगर वहां पे आपको शूटिंग करनी है तो यू नीड द परमिशन फ्रॉम द यू नो द अथॉरिटीज। बट अगर आप थोड़ा सा आगे ताजमहल आप परमिशन नहीं ले रहे हैं, दूर से दिखा रहे हैं, यू डोंट नीड द परमिशन, क्योंकि उससे ताजमहल पे इफेक्ट नहीं आ रहा है, सो यू डोंट नीड द परमिशन, दैट इज नॉट इन्फ्रिंजमेंट ऑफ आर्टिस्टिक वर्क। So, in all these cases, the act which the owner or the author was authorized to do, if you do that, that will not amount to infringement of copyright. So now, if a person is infringing your right, what remedies a person has? So there are different remedies, civil as well as criminal. Though हमारा जो intellectual property है ना, वो ज़्यादा criminal rights पे, criminal remedies पे focus नहीं करता है. उनका basic रहता है civil remedies में. Civil remedies where you get the compensation. So there are few remedies that are available for the infringement of copyrights. So one is one can apply for injunction. So if I am committing an act that is infringing your rights, in that case you can apply for injunction. Interlocutory injunction hai where the judiciary, if a person is threatening or invading my rights, in that case that person will be an injunction will be granted. But injunction grant करने के लिए, as it is provided under CPC and Specific Relief Act, you need to establish prima facie case. So आपको establish करना पड़ेगा कि rights आपके पास हैं. वो आप कैसे करेंगे? Registration के through. Though registration is not mandatory, so here the registration of copyright will help you out. So you have to prove that prima facie case is in your favor. Number two, balance of convenience and irreparable injury. If someone is publishing my work in his or her name, that will cause irreparable injury to my name, to me. All my rights are gone. आपने मेरा काम अपने नाम पे पब्लिश करवा दिया, लोगों में communicate हो गया, मेरे लिए irreparable injury है. So I have to prove all these things. Then Madhava injunction is provided. There, I don't know who is the person who is committing that infringement. So I'll apply to the court, and I'll get the injunction, and nobody will be allowed to copy my work. Anton Pillar order. So that is order named after the famous case of Anton Pillar KG versus manufacturing process. So here the court can award ex parte order restraining the use of copyrighted products against the defendant. So defendant के against order pass कर दिया जाएगा, that will be ex parte. So defendant will not be given a chance to represent himself, and an injunction to use those copyrighted, जो copyright करके work हो गया, so book publish हो गई है without my permission, without the permission from the publisher, उसको उसके यूज को रिस्ट्रेन करने के लिए ऑर्डर पास किए जाएंगे. दैट इज एंटन पिलर ऑर्डर. देन जॉन डीस ऑर्डर दैट सेज that injunction will be granted against unknown persons. Then there are pecuniary remedies also. Pecuniary remedies where a person can go opt for damages or account of profit. So either you will claim that this is the amount of profit that I might have earned from my copyright rights, which I could not because the other person infringed my rights. So you will give, unlawful conduct था उसका, उसकी वजह से whatever profit you might have earned, you will claim that, and court, if satisfied, will grant that amount to you. Next pecuniary remedy is compensatory damages. Now, this is not the profit that you might have earned. This is the loss that you have suffered, or the damages you have suffered because the other person infringed your rights. So that is damages. So damages or account of profit, injunction. These are three remedies that are available to a person whose right has been infringed. And also there are some criminal remedies, that is imprisonment, that may extend from 6 months to 3 years, or fine that will be from 50,000 to 2 lakhs. Also, court can order that the copyrighted work shall be searched and seized the place where there is doubt that there are some copyrighted goods which was copyrighted without permission or unauthorized goods, that place can be searched, and unauthorized those copyrighted goods can be seized by the authorities, and that those goods that were seized by the authorities will be delivered to the on person who is the owner of that copyright. So now this is brief about copyright law. There is one thing that I would I would like to add to this. International copyright की जब हम बात करते हैं, so there is one convention that plays a relevant part when we talk about rights under copyright law, that is Berne Convention. Now, Berne Convention में there are three principles that were given, and all the these countries who have signed or who have ratified this convention have to follow these three principles. So, in brief, those three principles are: one is principle of natural treatment, second is principle of automatic protection, and third is principle of independence of protection. सो जनरली क्या होता है, जब भी आप कोई भी इंटेलेक्चुअल प्रॉपर्टी राइट है, वेदर इट्स अ पेटेंट और ट्रेडमार्क और कॉपीराइट, दे आर टेरिटोरियल. These rights do not extend to the whole of world. So if I am in India, I will be protected according to the Indian law and within the territory of India only. If I'm in England or if I'm in Australia, US, Canada, so I'll be protected only within the jurisdiction of that act. So Canada ke law ke under Canada mein, US ke law ke under US mein, that protection is provided. But then we have these international conventions. Berne Convention is one of the oldest convention when we talk about intellectual property. So Berne Convention में तीन principles दिए गए. So if a country is signatory to the Berne Convention, they have to follow these three principles. First principle of national treatment. So I'm an Indian citizen. I apply for protection of copyright to in Canada or in US. So Canada or US, because they are the signatory of Berne Convention, they will have to give similar rights to me, which they have given to their own nationals. And vice versa, if a person who is a Canadian citizen applies for copyright protection of his literary, dramatic, or musical work in India, Indian government will have to give same rights to the Canadian citizen, all those rights which are being similar rights which are being provided to the Indian citizen. So that is principle of national treatment, that you will treat the citizens of other signatory countries as your own citizen only for the matter of those rights. ठीक है, जहाँ पे भी registration हुआ है, जहाँ पे भी allow किया गया protection, so all the similar rights will be provided to the Canadian citizens. Next is principle of automatic protection. So I'll get the protection in the signatory countries automatically. Yeah? And also the third principle, it says that I'll get the protection independently. So supposedly there is one right, say right to communicate to the public. It is not provided under Canadian law, but it is provided under Indian law. So in India, the Canadian citizen will get the right of communication to the public. It is not dependent upon the rights that are given to the person from his own country. So in India, if I'm an Indian citizen, I want to get my copyrighted work protected in Canada. So I'll get all the rights that are given to the Canadian citizen, similar rights. Whether that kind of a right is provided in my native country or not. So if a right is not there in India, but it is there in Canada, I'll get all those rights. That is how we connect it to the national treatment. Similar right to Canadian citizen, similar right to Indian citizen, even if that right is not provided in India or vice versa in Canada. So that is the principle of independence of protection. These are the three principles that were given in through the Berne Convention, which is one of the most relevant convention when we talk about intellectual property rights. Coming to the amendment that was done in Copyright Act in 1957 in 2012. So I don't know how many of you have heard, but at that time there was a big uproar against that amendment, that the people are given too much of rights under this amendment act. But obviously जिनकी अर्निंग कम हो रही थी उस पे इफेक्ट आ रहा था, सो दे डिडंट वांट कि ये अमेंडमेंट एक्ट पास हो और उनको राइट्स मिले, बट ultimately the amendment was passed, and Amendment Act of 2012 talked about performers and broadcaster rights. So if a person is a performer, choreograph, dance kar rahe hain, singing a song, the way a person performs, that person was the changes were made and they were given exclusive rights to their performance. I cannot perform a dance that was choreographed by another person. मेरी performance, so जो मेरी exclusive performance है, that is something original which no one else can do. वो सिर्फ मेरा एक talent है. Those rights, the right to perform that, the right to communicate that work to the public, that performance to the public, the right to publish that belongs to me only. No one else can use the performer's right. No one else can use that performance. So if I have performed, only I can communicate that work to the public. आप मेरी वीडियो बना के अगर किसी भी पब्लिक प्लेटफॉर्म पे ऐड करते हैं, that will amount to my violation of my performance rights. So that will be infringement of my performance right. In case of performance rights, the term is 50 years. So till 50 years, that performance belongs exclusively to me. No one else can communicate or publish that work to the public. अगर कोई और परफॉर्म कर रहा है विदाउट माई ऑथराइजेशन, अगर कोई और कम्युनिकेट कर रहा है, that will amount to infringement of my right as per the amended Copyright Act. Same way broadcasting right, जैसे मैंने आपको नेटफ्लिक्स के एग्जाम्पल दी. So I, being the producer of a movie, I give those broadcasting rights to Netflix. Now Netflix पे वो ब्रॉडकास्ट होगी. अब क्या हुआ? So there is a local platform supposedly. Obviously national international platforms ऐसा काम नहीं करेंगे, ऐसी हम उम्मीद रखते हैं. So any local platform, उसने सब्सक्रिप्शन ली नेटफ्लिक्स की, रिकॉर्ड किया और अपने लोकल प्लेटफॉर्म पे दिखा दिया. That will amount to infringement of broadcasting rights. So whenever I get the right to broadcast something, I get the right, exclusive right to publish, perform and not perform, communicate that work to the public and the broadcaster. हम सब क्रिकेट मैच जनरली सब देखते हैं. सो उसकी एक एग्जांपल है. सो अर्लियर देयर वाज ऐसा कोई रिस्ट्रिक्शन नहीं था, बहुत सारे प्लेटफॉर्म्स नहीं थे. सो बीसीसीआई ने कभी सोचा भी नहीं था. सो अर्लियर, अभी तो बीसीसीआई इज वन ऑफ द रिचेस्ट बोर्ड्स ऑफ क्रिकेट, ऑफ एनी play, I'll say, any sport after football. So earlier BCI used to pay Doordarshan for broadcasting the matches. तो इंडिया जितने भी मैच खेलता था उसका ब्रॉडकास्टिंग सिर्फ और सिर्फ दूरदर्शन पे होता था. एंड बीसीसीआई यूज्ड टू पे दूरदर्शन सो दैट दोज मैचेस कैन बी ब्रॉडकास्टेड. ठीक है, तो ऐड होगी, कुछ पैसे बनेंगे एंड उनका थोड़ा मार्केटिंग हो जाएगा. बट विद एडवेंट, दो क्रिकेट पहले से भी बहुत खेला जाता था, बट आफ्टर, इट इज सेड, आफ्टर सचिन तेंदुलकर केम इनटू, उसकी पॉपुलैरिटी रीच्ड अनदर लेवल. He is the one who actually also started commercialization. He went for the advertisements, etc. So now the Doordarshan started paying BCCI. अब जो BCCI वो ब्रॉडकास्टिंग राइट्स बेचने लग गया कि ये मैच है, यहाँ पे हो रहा है, इफ यू वांट टू ब्रॉडकास्ट दैट यू हैव टू पे अस. पॉपुलैरिटी बढ़ गई, मनी इन्वॉल्व हो गई ज्यादा. So in that case, people wanted to see Sachin Tendulkar playing. People wanted to see other players playing, Rahul Dravid, Saurav Ganguly. So BCCI started charging Doordarshan. Later on, few channels like ESPN, Sony, Star Sports, they came into the picture and they started paying more. है ना, उन्हें लगा था कि एक्सक्लूसिवली हम दिखाएंगे, हमें एड्स मिलेंगे. Now, Doordarshan had to file a suit in the court that please allow us to broadcast these matches. Okay? So, specifically when World Cup is there, so everyone wants to watch World Cup matches. So, अभी भी बहुत जगह ऐसा है जहाँ पे these private channels are not available. So, court allowed कि जितने भी matches में India play करेगा, those matches will be broadcasted on DD, Doordarshan. So that is the power of broadcasting. Now, so अब क्योंकि इतना importance मिल गया था, इतनी relevancy हो गई थी, so 2012 talked about amendment added this broadcasting rights also. So this is one factor. It is not only that because of the cricket match broadcasting ये broadcaster rights है, other भी हैं, जैसे पहले सिर्फ दूरदर्शन पे मूवीज आती थी, लेटर ऑन केबल नेटवर्क आया, फिर दीज स्टार प्लस एंड जी, सोनी सब एक एक करके आने लगे, एंड देन नाउ ओटीटी, दे ऑल वांट, है ना, हम सबको लगता है कि थिएटर में क्या जाना है, घर पे बैठ के देख लेंगे. देयर आर मेनी पीपल लाइक दैट. सो broadcasting got the relevancy and importance and significance. So in 2012 the broadcasting rights were added in copyright. So if I have those rights of broadcasting, no one else has the right to publish or communicate that work to the public. Only the person who has the broadcasting right, who has earned it, though it is through any tender or koi agreement hai, in that case, only that particular platform can broadcast that right. That is broadcasting right. Now, these broadcasting rights are available for 25 years from the first publication, obviously. So for 25 years, Netflix or Doordarshan or ESPN or Star Sports or Jio Cinema जो IPL दिखाता है, so they have those rights that they can reproduce that time and again. So earlier ESPN was, dominating when we talked about sports broadcasting. धीरे धीरे everyone started pouring into Star Sports start हो गया, सोनी ने अपना स्पोर्ट्स का चैनल स्टार्ट कर दिया, जियो सिनेमा आ गया. So ESPN has the rights to broadcast few matches जो पहले उन्होंने एग्रीमेंट ले लिया था. Till 25 years they can broadcast those rights. I'll share one thing. So I have been a big Sachin Tendulkar fan. So the match he played in Sharjah against Shane Warne, when like it was said कि Shane Warne के सपनों में आने लगे हैं Sachin Tendulkar, ESPN used to broadcast that match 3 times in a week क्योंकि उन्हें पता था लोग देखेंगे, है ना. उस टाइम पे सचिन तेंदुलकर का क्रेज बहुत था, सो लोग देखते भी थे. Because they have the right of broadcasting, they can reproduce that match or that broadcasting time and again. तो वो रोज दिखा देते थे. So even if like जैसे अभी हमारे जितने भी जहाँ केबल नेटवर्क्स हैं और ये जो OTT पे तो आप एनी टाइम यू कैन वॉच दैट, है ना, बट अदरवाइज जैसे केबल चैनल्स हैं, जैसे स्टार प्लस है और सोनी है, KBC Sony can play n number of times till 25 years. They have that broadcasting right, but after that they cannot. Okay, so they get the right to communicate and to reproduce that work time. That is broadcasting rights. Okay, I think it's time. I think it's enough. वैसे we have few judgments, and I also wanted to talk about digital copyright, but maybe some other time. So that's it from my side. That's all about the copyright, all the rights that are provided, and infringement, if any. So if there is any query or any question, I'll be happy to answer.
There are some questions, ma'am. May I please share them to you?
Yes, please do that.
So the first question is, with the rapid rise of digital content creation and sharing platforms, what do you see as the next big challenge or evolution in copyright law, particularly in the Indian context?
Yeah, obviously, I said that I wanted to talk about digital copyrights. There are n number of issues that are involved in digital copyright. See, as I said in the starting, and when we started the session, that it's really easy to copy everything now. When I give my assignments to the students, I know most of them might be copied. So next, if you people are aware, we have now the data protection law. So I do see that there will be another amendment. There shall be another amendment in copyright law where we will be providing protection to the digital copyright also. So if I am creating, like, I'll take an example of this Instagram Reels. So when you see a reel, there are n number of people who are copying the dance steps or the songs they are being played. It's a public platform. I don't think that shall be done, but then there shall be a regulatory authority or regulation. Like जैसे मैं हमने infringement में मेरा copyright डाला for literary work, there shall be some amendments. I think there shall be some amendment in the copyright law so that we can regulate the infringement that is done through digital copyrights, this digital platforms. Right. So if I am writing an article and you're there are few OTT platforms, there are few, not OTT, sorry, online platforms. So if you need, they are protected. They are copyrighted protected. You cannot copy them just like that you copy them and you paste them in your assignment or your article. So those kind of efforts and amendment in copyright law, I think that will help to some extent address the issue of digital copyright. This is what my take is on this issue. And I think being into the legal field, you all shall write to the Ministry of Information and Broadcasting as well as Ministry of Law to add this or to pass another law like we have this data protection. We shall be able to protect our creative work also. Yeah.
Ma'am, the next question is related to digital platforms only. With the growing use
Okay.
of digital platforms for sharing and distributing content, what strategies do you believe are most effective for enforcing copyright protections in this ever expanding digital landscape?
So see, when we talk about digital OTT platforms, so as I said, the rights can be transferred. So if I am the producer, they are not copying the work, they are getting the rights. So if I am a producer, abhi Netflix, Amazon ka kya hai? But they do is they say they are the producers themselves. Na? They invest in that. So a person who is investing, they are getting the rights. They are the owner of. They are not copying anything, they are getting the copyrights transferred to themselves. So Netflix, or for that matter any cable operator, they do not copy the work, they do not infringe the rights of the copyright, honor of the copyright. What they do is they get those rights transferred. See, all the rights that I have discussed, a person who is the owner of the copyright or who is the author of the copyright, it's not mandatory कि मैंने आपको अगर सिर्फ publish करने का right दे दिया तो सारे rights आपके पास आ गए. All these rights of production, of reproduction, of translation, of adaptation can be transferred to different people. So I can transfer, say, reproduction right to Yashika, and I can transfer adaptation right to Dia, and I can transfer translation right to some other person. So all these OTT platforms, platforms are not infringing the copyrights. They are paying the producers, and they are getting those rights transferred to themselves. So they're free to communicate that work to the public because the rights are now transferred to them. So that is not counted as infringement. Yeah.
So, ma'am, the next question is, as artificial intelligence is increasingly used to generate content, how do you think copyright law will evolve to address authorship and ownership in such cases? Are current laws
Yes.
equipped to
So
handle these developments?
no, 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 not at all, not at all. So I had these two things in mind, uh, digital copyright as well as artificial intelligence. So artificial intelligence, I'll share one experience. So जैसे कहा जाता है, artificial intelligence is not very good for research or other things. So I attended a workshop on artificial intelligence, and the person said that some of the professor, he said, I think it is okay to use chat GPT. कुछ पढ़ोगे, अब चैट जीपीटी आपने भी देखा है, मैंने भी देखा है. आई विल नॉट अलाउ द कॉपी एज इट इज, ऑब्वियसली. ठीक है, एज अ टीचर आई विल ऑल्सो रिसर्च ना. आई एम नॉट गोइंग टू जस्ट सिट एंड सी कि ठीक है तुम चैट जीपीटी से लिख के ले आओ. So he said, I am happy if my students are using chat GPT because at least they are studying something. Same goes with digital content also. But then obviously artificial intelligence is getting too much on our nerves. Uh, I'll talk about one judgment here. So there is a judgment of UK Supreme Court. We don't have any law to regulate artificial intelligence till date. अभी तक के लिए वी आर वेरी हैप्पी कि देखो ये भी हो रहा है, अलेक्सा सब कर रही है, मुझे तो बेड से उठने की भी जरूरत नहीं है. वो मेरी लाइट भी ऑन कर देगी, वो लाइट ऑफ भी कर देगी. वो फोन, अगर स्मार्ट फैन है तो उसमें फैन भी ऑन कर देगी. अभी के लिए वी आर हैप्पी डूइंग दैट. बट ऑब्वियसली आप सबको भी कॉल्स भी आते होंगे, मेल्स भी आती है, मैसेजेस भी आते हैं, बट दे आर गेटिंग इनटू आवर प्राइवेट लाइव्स, है ना. सो very quickly we are going to realize that artificial intelligence is not that advantageous for us. deep fakes हम सब ने देख ली हैं, प्रधानमंत्री के बन गए और तो किसी को क्या ही हम प्रोटेक्शन प्रोवाइड करेंगे. सो ऑब्वियसली वी डोंट हैव द लॉ, we don't have the judgments, we don't have any regulation on artificial intelligence only in our country actually, not even outside. I think there are not much of the countries that are regulating artificial intelligence through law right now. But then there was one judgment, Theller versus Comptroller General of India. This is the UK Supreme Court ka judgment hai, where Dr. Theller, he created a machine Debus, DABUS. So he asked, अब Debus ने एक invention करी. So Dr. Theller said that machine shall get that artificial intelligence, obviously. So that machine shall get the inventorship. That machine shall be recognized as inventor of that particular product, whatever was created. But the court rejected that. Court said there shall be some human. So artificial intelligence or the machine, they are not actually a person. Leave aside legal person or natural person. That is what the court has said. A natural person to chhodi dijiye, it is not even a person. So we are not going to recognize that machine or any artificial intelligence mode as the inventor or as the owner of the right. So there are very few judgments on this, but we don't have any regulation. And again, I'll say at very, बहुत ही jaldi and very soon, and at some point you have to regulate that, because if the artificial intelligence keep on growing like this, it is going to affect each and every aspect of our lives. So it shall, आई डोंट नो, ह्यूमन नेचर होती है, हम चीज़ों को डिसएडवांटेजेस और नेगेटिव चीज़ों के लिए कई बार ज़्यादा यूज़ करते हैं इंस्टेड ऑफ पॉजिटिव. इफ वी सी द पॉजिटिव साइड, इट्स ओके, बट देन and I also, to some extent, that's my personal belief, why we keep on putting everything on the government. Law ही क्यों बने? Why don't we restrict ourselves? Why go to chat GPT every time? Why not go to books? है ना, अपने भी थोड़े पर्सनल एफर्ट्स डालेंगे. गवर्नमेंट, फिर हम कहते हैं गवर्नमेंट कुछ नहीं कर रही है, कर तो हम भी नहीं रहे हैं, हम भी गवर्नमेंट के ऊपर ही डाल रहे हैं कि तुम कर दो, तुम कर दो, फिर हम देखेंगे, आप रेगुलेट कीजिए. तो व्हाई नॉट रेगुलेट आवरसेल्व्स टू सम एक्सटेंट, है ना. स्टेप्स पूरे करने के लिए हम वॉक करते हैं, तो थोड़ा अलेक्सा से काम भी कम करवा लें. So obviously regulatory authorities are needed for whether it's digital content or whether it's artificial intelligence created products. We need to regulate that, else disadvantages or negative uses zyada honge. And I have always personally believed that we shall not put everything on the law or the government. Let's restrict ourselves also. Yeah, that's a personal advice though.
Thank you so much, ma'am, for all your answers. That
Thank you. I
those
hope
were
I
all the
was
questions we
able
had.
to. Okay, I hope I was able to answer them in a good way, and I hope I was able to explain a bit about copyright, and you people could understand what I was trying to communicate. Thank you so much.
As we conclude this insightful webinar, I would take this opportunity to deliver a heartfelt vote of thanks to everyone who contributed to the success of today's session. First and foremost, our deepest gratitude goes to our esteemed guest speaker, Dr. Manisha Narula, Associate Professor at the School of Law, Manav Rachna University. Ma'am, your invaluable insights into navigating the complexities of copyright law in India have given us a clearer understanding on the intricate legal frameworks governing creative industries. Your thoughtful discussion on topics like rights, authorships, and infringement issues in the digital area has provided us with valuable knowledge that will no doubt benefit us in both our academic and professional journeys. I would also like to acknowledge the incredible enthusiasm of our participants today. Your engagement has made this webinar all the more dynamic and impactful. A big thank you to the organizing teams at CDIPR and Navina for their behind the scenes dedication and hard work. It is your careful planning and flawless execution that have made this event a success. With that, I once again thank everyone who contributed to today's event and made it memorable and enriching experience. We hope to see you all in future events. Wishing you all a wonderful day ahead.
Thank you, Yashika, and thank you, Dia. Thank you, everyone who came and joined and participated. Thank you so much.
Thank you, ma'am.
So I can leave now?